Well, there was a ripeness problem from before, but
Aye.
okay, guys, how's everybody? Can everyone hear me at home? Can I have a thumbs up or someone acknowledging at home?
Yeah.
Okay, great. All right, we have a lot to cover today, so let's get going. We're finally starting to do the individual liberties part of the class. Unfortunately, before we can jump into it, we have to do a little bit of table setting here. And the table setting creates a fair amount of confusion for law students, unfortunately. You'll see how the Supreme Court has sort of backdoored its way into some of these issues that I think could have been settled a lot more easily. So we're going to start first with something called the incorporation doctrine. The incorporation doctrine, which was really created to deal with two cases that we're going to talk about here. The Barron case that we're about to start with right now, as well as the slaughterhouse cases that we'll do in just a little bit. Barron is one of the last decisions that were written by John Marshall prior to his death. And here, essentially, we'll be talking. One of the individual rights we'll be talking about is the right not to have your property taken by the government without just compensation, the so-called takings clause. And this is an early attempt of a guy named John Barron to bring a takings case against the city of Baltimore. He owns real estate in Baltimore. It has a wharf on it. And, obviously back in the 1830s, one of the principal methods of shipping goods was by boat, okay? His wharf was profitable. I imagine he charged boats to lease and to unload and to haul cargo from there. City of Baltimore was doing some infrastructure work, constructing streets, and it somehow causes the water to change its course and directs the flow of the water away from the bay or the area where the wharf was. And all of a sudden it was too shallow to bring boats in and out of, and he loses his business. So, pretty good takings claim here is that an action by the government caused his property to become valueless. And so he's seeking to sue for his, the losses that he has sustained. And he's using the takings clause. So here's the problem. The Supreme Court dismisses the case. And it dismisses the case because it says that the Bill of Rights, and really, the 10th Amendment, although it's part of the Bill of Rights because it was created at the same time as the other 9 amendments, it's really not an individual rights provision in the Constitution. It's a federalism provision, as we've talked about already. But, we're going to examine here the first 9 amendments to the Constitution provide what we think of today as the individual rights that the Constitution provides. So what John Marshall does is he says, those amendments to the Constitution only apply to bad acts by the federal government, not to state governments. If you are complaining that your right of free speech, your right not to have your property is taken, your right to practice your religion, whatever individual right you're looking to defend, you need to, if it's the state who you claim has interfered with the exercise of those rights, you need to look to the state constitution, not the federal constitution, because the Bill of Rights clearly says, think of the First Amendment, okay? For the first words of the First Amendment are, Congress shall pass no law, okay? And what the Supreme Court has done has interpreted that to mean that the First Amendment only applies to the federal government interfering with your free exercise rights, free speech rights, and the like. The states are free to interfere with them, and it won't be a violation of the federal Constitution, okay? So in this case creates a problem for us, for the next more than 100 years, okay? So bottom line is, if it's the state that interferes with your right to free speech under the First Amendment, you have no recourse unless the state constitution only has a First Amendment clause. Now, the Massachusetts Constitution does have most of these clauses. We have a takings clause. We have the equivalent of a free speech clause, a free exercise clause. All of these criminal protections we have in the Massachusetts Constitution, which largely served as a model for the federal Constitution, but not every state does. And apparently Maryland has no Fifth Amendment takings clause for Mr. Barron to be able to redress his damages through. So he's essentially left, pardon the pun, he's essentially left high and dry, essentially. So here, if it's the state, they can interfere with your right to free exercise, free exercise of your religion. They can quell free speech. They can seize your property without a warrant. They can subject people to double jeopardy. There's no right to remain silent. They can take property without just compensation, no right to a speedy trial. All these things are in the Bill of Rights, okay, that are listed on this slide. No right to confront witnesses, no right to a jury trial, no right to be free of cruel and unusual punishment. Okay, these are all the rights that apparently only apply through the US Constitution if the federal government is the culprit, okay? So the 14th Amendment, about 35 years after the Barron case, is ratified, and it contains a privileges or immunities clause. I should have called that the privileges or immunities clause. It doesn't make a whole lot of difference, but in Article 4, it's the privileges and immunities clause. And in the 14th Amendment, it's the privileges or immunities clause. And it really is a distinction without a difference, to be honest. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, okay? That is the privileges or immunities clause of the 14th Amendment. You can make an argument looking at that provision that the privileges and immunities clause intends the Bill of Rights to apply against the states as well as against the federal government. Now, remember what happens with the 14th Amendment. These are the so-called post-Civil War amendments. We've already taken a brief peek at this. This is the response to the Civil War in the situation of slavery. So the 13th Amendment abolishes slavery, but Congress, when it writes the 14th Amendment, knows that even if you get rid of slavery, in its formal sense, you're going to have de facto slavery. You're going to have still a lot of prejudice and a lot of discrimination against former slaves. So it passes the 14th Amendment, and it puts in this right to due process that is also present in the 5th Amendment, creates the Equal Protection Clause, which is not present in the Bill of Rights. And it creates this Privileges or Immunities Clause, which is present in the body of the Constitution. Article 4, we've already talked about privileges and immunities under Article 4, okay? Now it's made to apply to the states through the 14th Amendment, okay? And the first three operative words of the 14th Amendment are no state shall, right? So instead of Congress shall not, which is in the Bill of Rights, which is geared towards the federal government, the 13th, 14th, and 15th Amendments are realizing, hey, there's this, rampant discrimination and slavery going on here, and we've got to get rid of this. And it's not the federal government who's the culprit, it's the states who are the culprit here. So we have to take some of those individual protections that are contained in the Bill of Rights and make them applicable to the states, okay? And one could say the Privileges or Immunities Clause of the 14th Amendment, which the whole idea of it is to make the states treat everybody the same, okay? So, there's a good argument here that the Privileges or Immunities Clause has essentially sucked up the Bill of Rights and made it applicable to the states, except for the slaughterhouse cases, okay? That came along in 1873, a very short time after the 14th Amendment was passed, 5 years. Here, for economic reasons, the Louisiana legislature gives a monopoly to one slaughterhouse in the city of New Orleans, the Crescent City Livestock Landing and Slaughterhouse Company. It essentially says no other company will be slaughtering livestock. Butchers will have to go to the Crescent City Livestock Company and have their livestock slaughtered for a fee. So it puts other slaughterhouses essentially out of business. So they sue. They claim that this is involuntary servitude under the 13th Amendment. They say it deprives their property without due process of the law. And there is a due process clause in the 14th Amendment. They say this denies them to equal protection under the 14th Amendment. It's true they are being treated differently from the Crescent Slaughtering Company. And it denies them the privileges or immunities under the 14th Amendment. And the court basically says, no, 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 no. No cause of action here. 13th Amendment applies only to slavery, not to discrimination. 14th Amendment applies to only one class, former slaves. That's who it's trying to protect. You're butchers. You're not former slaves, okay? Privileges or immunities, and I don't even know what it's thinking when it says this, applies to citizens of the United States, not to the citizens of states. Well, to be a citizen of the United States, you have to be a citizen of a state. In the 14th Amendment says that, people born in the United States are citizens of the state that they reside in and of the United States. So this is just a trick, a canard that the court is using not to apply the argument that we just discussed, saying that the Privileges or Immunities Clause of the 14th Amendment sucks up the protections of the Bill of Rights. The court, with very little discussion, blows off due process and equal protection. It essentially writes the Privileges or Immunities Clause out of the Constitution. The 14th Amendment Privileges or Immunities Clause is written out of the Constitution. When I took the bar exam, and admittedly this was a long time ago, 1981 was a long time ago, okay? When I took the bar exam, they instructed us, we were never to choose that a plaintiff wins under the 14th Amendment privileges or immunities clause. You could only win under the privileges and immunities clause of Article 4, okay? So that's the way it remains. And then typical Supreme Court decides to confuse us. Once again, with the case of Sayans versus Roe in 1999. California was obviously worried about people moving to California in order to get enhanced state benefits from California. So it decided that in order to discourage people from out of states moving to California to get the California benefits, it would create a durational residency requirement. It would say that you have to live in California for 12 months before you can get full welfare benefits. This gets challenged by Roe. Obviously, whenever you see Doe in Roe, that's a pseudonym for someone who doesn't want to be identified in the case. Okay. Roe versus Wade. We'll talk about that case later on as well. Challenged under the privileges or immunities clause of the 14th Amendment. Okay. I'm being discriminated against because I'm from another state. And what does the Supreme Court do this time? It, for the first time since the slaughterhouse cases, it recognizes that you can use the privileges or immunities clause of the 14th Amendment. And so it decides the case, under the 14th Amendment P&I clause. Protection comes from two sources: as a citizen of a state and as a citizen of the United States. And what this really does is it prevents people from traveling freely among the states. So it interferes with their right to travel from state to state and to be treated equally when they arrive at the new state. Great. All of a sudden, privileges or immunities, I'm sorry, guys, this is the world you live in. All of a sudden, privileges or immunities can be a correct answer on the bar exam if it's under the 14th Amendment. Not just under Article 4, but also under the 14th Amendment. However, it's been 21 years since Sayans was decided, okay? Sayans was decided in the year that Prince was going to party until it was, right? 1999. It's been 21 years since Sayans, and the Supreme Court has never come down with a similar holding again. It has never used the privileges or immunities clause of the 14th Amendment. The only justice who seems willing to do this, and he puts it in his dissents and concurrences, is Clarence Thomas. He says that he would give weight to the privileges or immunities clause of the 14th Amendment, and he would treat it essentially the same as Article 4 privileges or immunities. And he thinks that, that's what gives states the right to, not states, individuals the right to hold the states responsible for violations of the Bill of Rights, okay? So you got the slaughterhouse cases, you've got the Barron case, you have this slight aberration or maybe a wrong turn, if you want to call it that, in the other direction. And you have a federal Supreme Court that coming into the 1930s is becoming very troubled by what it's seeing going on in regards to state abuses, particularly in the area of criminal law. So, we grow up to think that everyone should have the right to a jury trial. Everyone should have a fair trial, the right to due process of law. Everyone should have the right to be free of discrimination. Yet in the criminal realm, all of these rights don't apply in many of the states because their state constitutions don't guarantee them. And the reason for that is because of the Barron case and the slaughterhouse cases. So in the 1930s, the Supreme Court, feeling troubled, decides it has to start to go in a different direction, okay? Now there's two sort of courses that the Supreme Court could have taken. Number one, it could have said Barron and the slaughterhouse cases were wrong. We're overruling them, and we're saying that the Bill of Rights applied to the states equally, just as they do against the federal government. The other thing it could do is what the Supreme Court always seems to do, which is to refuse to overrule a case that it wants to overrule, at least in effect, claims that the case still isn't there, but come up with another method to achieve the same result, okay? Bear with me for a second, Teddy. And so this is what the Supreme Court does, is it creates the incorporation doctrine, okay? Now, Teddy, you have a question. Take yourself off of mute. Before I get into incorporation, I'll take your question.
Well, you were talking about how the Supreme Court is very clear they don't want to be a legislator in that regard. So if they were to then immediately then overturn a case, wouldn't that kind of play into that idea that they're playing legislator, where they're now like, oh, we made a mistake, never mind, kind of going back like.
Yeah. Okay. So I assume, why don't you mute yourself again? I assume you all heard Teddy at home. Separation of powers says that the Supreme Court should not be a super legislature. So isn't overturning a case the Supreme Court essentially saying that it is a super legislature? And under that argument, Teddy, there would be no such thing as an overruled case or an overturned case, right? So in other words, if the Supreme Court makes a decision that seemed right for 1802 or 1803 was Marbury versus Madison, okay, then it would be stuck with it forever, even though technology changes, American culture changes, societal values change, over time, and then you could never do that. What the Supreme Court would be saying is that it is interpreting not policy decisions, but it's just reinterpreting the Constitution. Now, certainly originalists buy your argument a lot more than non-originalists, right? And we'll see that when we get into the state action doctrine, how originalists just don't want anything to change. And so a true originalist would not believe in the right of privacy in the Constitution because it's not written into the Constitution. And the true originalist doesn't like, we'll talk about Griswold versus Connecticut, in this very attenuated, indirect way of coming up with the right of privacy that has become a fundamental right in the Constitution, okay? So, some people would agree with you, potentially, or your point, potentially, but then the law would never change. And originalists don't think it should change. Like, we have to go back and get into the heads of the framers of the Constitution. The framers of the Constitution, didn't believe that women should have the right to vote. The framers of the Constitution, not everyone embraced slavery, but many of them certainly did. Cultures and values change. All right, let's talk about incorporation. There is in the 14th Amendment a due process clause. There is also a due process clause in the 5th Amendment. So again, just to sort of reorient ourselves here. The 5th Amendment is part of the Bill of Rights. The Bill of Rights only protects us from federal intrusions. The due process clause is in the 14th Amendment. The 14th Amendment expressly says that it only protects us from state intrusions. And then the 14th Amendment introduces a whole new concept that wasn't in the Bill of Rights, concept of equal protection of the laws, okay? So the Bill of Rights would not apply to the states. The Equal Protection Clause would not apply to the federal government, but for this incorporation doctrine that we're about to lay out, okay? So what the incorporation doctrine says is this: the Due Process Clause of the 14th Amendment, which is also part of the Fifth Amendment, sucks up the Bill of Rights through it and makes them applicable against the states, okay? To some degree, equal protection and due process overlap, the courts say, okay? And in reverse, the Due Process Clause of the Fifth Amendment sucks up the 14th Amendment Equal Protection Clause and makes that applicable against the federal government, even though the Equal Protection Clause is contained in the 14th Amendment, which begins with no state shall, okay? And so, for example, one of the cases we're going to do when we get to equal protection is the Korematsu case. The Korematsu case is the Japanese internment camp case. After the bombing of Pearl Harbor, the federal government took virtually every single person of Japanese ancestry on the West Coast and put them in internment camps in the middle of the country because it was afraid, it claimed, of loyalty to the Japanese Empire. Most of these people were born in the United States and were, you know, as American as you and I. Without this incorporation doctrine, Fred Korematsu could not have claimed that he was discriminated against by the federal government, okay? So you'd have no Korematsu versus United States. In the end, Korematsu got screwed anyways, but it wasn't by applying the Barron case, you know, and it wasn't by applying the slaughterhouse cases either, okay? So again, the concept is this. Do you see why it would have been so much easier to say that the Privileges or Immunities Clause of the 14th Amendment now makes all of the Bill of Rights applicable to the states, instead of saying, well, we got the Due Process Clause in both the Fifth Amendment and the 14th Amendment, and they suck out the other two, you know, the opposite side to apply to either the state or the federal government, right through that Due Process Clause. And let's give it a fancy name. Let's call it incorporation. The Due Process Clause of the 14th Amendment incorporates the Bill of Rights into it. The Due Process Clause of the Fifth Amendment incorporates the 14th Amendment into it, okay? And that's our doctrine of incorporation. On the day that Brown versus the Board of Education was handed down, a sister case of Bowling versus Sharp was handed down. And this illustrates how incorporation applies against the federal government. Brown versus Board of Education of Topeka, Kansas was against state school systems. You know, municipalities are political subdivisions of the states. Washington, D.C., as we remember from reading Article 1, Section 8, is within the province of the federal government, not any state government. So in the DC school system, the Bill of Rights always applied to the DC school system. But what was missing from the Bill of Rights? An Equal Protection Clause. And if the Equal Protection Clause only applies as to the states, then the District of Columbia can go on engaging in the segregation of its schools, separating out Black students from Caucasian students, okay? So the court here uses this doctrine of incorporation, and it says, here's your description of it right here. The legal problem in District of Columbia is somewhat different. He's comparing it to the states. The Fifth Amendment, which is applicable in the District of Columbia, does not contain an Equal Protection Clause, as does the 14th Amendment, which applies only to the states. But the concepts of equal protection of due process, both stemming from our American ideal of fairness, are not mutually exclusive. The equal protection of the laws is a more explicit safeguard of prohibited unfairness than due process of law, and therefore we do not imply that the two are always interchangeable phrases. But as this court has recognized, discrimination may be so unjustifiable as to be violative of due process. So again, we're taking the Equal Protection Clause, sucking it through the Due Process Clause of the Fifth Amendment to make it applicable against the federal government as well, okay? So here's where the big dispute came. All of the justices seem to agree that there's a lot of bad stuff going on in the states. So, you know, we're gonna have to make some of these Bill of Rights, some of these individual protections in the Bill of Rights applicable for use against the states. But they fell into one of two camps. There was the so-called total incorporationist camp. They wanted to, in one fell swoop, say all of the Bill of Rights, every individual right under the Bill of Rights applies against state defendants just as it does against federal defendants, okay? And they're the total incorporationists. And the two big standard bearers for the total incorporationists were Hugo Black and William O. Douglas. The other justices, the other side, was the selective incorporationists. They wanted to do them one at a time. They said, you know, there's sort of like differing importance among the individual rights contained in the Bill of Rights. Some of those rights are incredibly important, and others of those rights are less important. We think that not all of them should be incorporated for use against the states. So we're going to only incorporate those that go to fundamental fairness implicit in the concept of ordered liberty. And indeed, that was sort of the language that Chief Justice Warren used back in the Bowling versus Sharp case, the American ideal of fairness. Here we have the language now. Those rights in the Bill of Rights that are essential to the fundamental fairness implicit in the concept of ordered liberty will be incorporated. And the way we're going to decide this, and the selective incorporation is one, at least in the short run, the way that we're going to decide this is that we're going to incorporate them one at a time. As a case comes up, we'll make the call. Should this one be incorporated? Is this one so important? Does it run to our concept of ordered liberty? So the selective incorporationists had the majority, and they prevailed, and we started clicking those off sort of one at a time. Today, there are very, very few rights, and I'm not going to run through all these cases. I'm going to sort of summarize them on the next slide. I'm going to do a couple of cases, though. There are very, very few rights that are not incorporated through the Due Process Clause of the 14th Amendment or through the Due Process Clause of the Fifth Amendment. The key here is to go back and to think about our introduction to the 11th Amendment. Remember the 11th Amendment, state sovereignty? And remember, we spent all of our time on the third exception to the 11th Amendment. Congress can waive sovereign immunity as to the states under the enforcement provisions of the 14th Amendment, Section 5 of the 14th Amendment, okay? But only when it is heightened scrutiny. Only when it involves, remember, national origin, race, alienage, gender, and here's the big one we're going to talk about, fundamental rights. Is it a fundamental right? Okay. If the Bill of Rights, if the right we're looking at in the Bill of Rights is a fundamental right, then we're going to incorporate. If it is not a fundamental right, we are not going to incorporate. Okay. So here's what's happened over the years. Fifth Amendment, right to be free of takings without just compensation. Fundamental right, incorporated. Right of free speech, press, and religion under the First Amendment. Fundamental right, incorporated. Right to be free from unreasonable search and seizure. Fourth Amendment. Right to be free, incorporation. You guys have probably taken criminal procedure already. So you recognize Mapp versus Ohio is still, I assume it's still an important case, right? The right to be free from compelled self-incrimination. Fifth Amendment. The right to assistance of counsel. Sixth Amendment. Gideon versus Wainwright. The right to a speedy trial. Sixth Amendment. The right to a public trial. Sixth Amendment. The right to confront witnesses. Sixth Amendment. More recently, as of 2010, the individual right to bear arms for self-defense. That is the first, I'm sorry, 2010 was the McDonald case, which we'll take a quick look at in just a minute. The first case was the Heller case, Heller versus District of Columbia. District of Columbia is part of the federal government. Second Amendment applies to the federal government under the Bill of Rights, okay? District of Columbia had a law that essentially banned all handguns, with some exceptions, you know, if you're a cop, obviously, but with a few exceptions. The city of Chicago has a almost exact law. In order to determine that the Second Amendment is applicable against the states, you have to create an incorporation argument. You have to incorporate the Second Amendment as a fundamental right, okay? And we'll get to McDonald in just a second. Before we do that, these are the, actually, I didn't even finish, did I? The most recent case we're going to do today is the Timms versus Indiana case. We'll go through that quickly. The right to be free from excessive fines under the Eighth Amendment. The Eighth Amendment doesn't only apply to cruel and unusual punishment, it also applies to excessive fines being unconstitutional. There are three rights that are unaccounted for, that have not been incorporated here. The right to not have troops quartered in your house, okay? That's the Third Amendment. Pretty solid reason why that has not been incorporated. We have not fought a war on domestic soil. So we don't have troops running around fighting and needing to be quartered in houses. So, that we just haven't had a fact pattern come up that would lead to a case that would see whether that should be incorporated. The right to a, go ahead, who's that?
Hi, this is Linda.
Hi, Linda.
Can you help me with the whole notion of posse comitatus versus what you just said about the Third Amendment? I must not have those straight.
Posse comitatus is not part of the Constitution. Posse comitatus is a statute that Congress passed that probably, quite frankly, lines up more with the Second Amendment than the Third Amendment. The original intent for the Second Amendment was not what the Supreme Court considers it to have been. They got that wrong. They got the history wrong. The framers wanted, there's two things that they didn't want. They didn't want a monarch and they didn't want a standing army. And they thought that the two went together, okay? The standing army kept the monarch in power despite what the people thought of the monarch. Second Amendment was about militias and making sure that there's no need for a standing army, okay? Now, it happens that there are other reasons to consider the Second Amendment as an individual right, but it's not an originalist reason. And I strongly disagree with the logic of the Heller case because of that. Okay. I think you have to have a non-originalist reason to say that there's an individual right to bear arms in this country. And I think you can find it if you know you lean in that direction. It's not that hard to find, and I'm not going to get into it now. Posse comitatus was passed essentially in order to sort of preserve this notion that we don't want standing armies that are running around the domestic landscape. So posse comitatus, Linda, tells us that we can't use our troops to run around doing things like policing. And I know the whole thing came up recently when the president used some federal forces to go down to the border and to help there. A lot of people said that was a violation of the posse comitatus law that was passed in the United States. But that doesn't really have much to do with quartering of troops. To my knowledge, federal authorities at the border were not, people weren't forced to give up their houses so that troops could be quartered in their houses. So does that help, Linda?
Yes, definitely. Thank you.
Okay. All right. So, and then, I don't know why there's no right to a grand jury indictment in a criminal case. In the federal courts, you can't be indicted except by a grand jury. That's not true in the state courts. There's more than one way to indict someone. I think that's true in Massachusetts as well. I'm not a criminal attorney. And then finally, the right to a jury trial in a civil case under the Seventh Amendment. A lot of states don't have those as well. So just about all the other rights have been incorporated to the point where if it weren't for the bar exam, you wouldn't even have to think about incorporation in most cases, okay? Whether you're suing the federal government or the state government. That's how much it has become. So McDonald versus City of Chicago, I've sort of set this up for you already. The Heller case had been decided a few years earlier. The Heller case applied strictly to the District of Columbia. The District of Columbia is federal. Don't have to worry about incorporation if the federal government is the defendant. So it's the federal government that's depriving Heller of his Second Amendment rights. The Second Amendment is part of the Bill of Rights and has always applied to the federal government. So you don't have to use the incorporation argument. City of Chicago is a different story, however. City of Chicago is obviously a political subdivision of the state of Illinois. And if the Second Amendment doesn't apply against the states, then McDonald has no right to carry a firearm in the city of Chicago because it's not a violation of the Second Amendment. So the Supreme Court in McDonald ends up finding that the Second Amendment right to bear arms for the purpose of self-defense, it's a bit limited, by the way. The Heller decision doesn't say right to bear arms for any reason at all. It says for self-defense. That's integral to Justice Scalia's decision. Okay. Justice Alito writes the McDonald case. And again, this was a hotly contested case. It was a plurality decision. The dissents were very sharp, very colorful, as is often the case. But Justice Alito said that Second Amendment rights to use firearms for self-defense are fundamental to the nation's scheme of ordered liberty. Deeply rooted in the nation's history and tradition, are appropriate for incorporation. The right to self-defense was one such fundamental and deeply rooted right. Because of the holding in Heller, the Second Amendment applied to the states. Justice Stevens disagreed. He argued that the right to owning a firearm is not a major part of our ordered liberty. Breyer, Ginsburg, Sotomayor also dissented. Again, nothing in the Second Amendment's text, history, or underlying rationale that characterizes it as a fundamental right, warranting incorporation through the 14th Amendment. Prior to the Heller case, virtually every single federal case that was decided on the Second Amendment, and there wasn't a Supreme Court case, but virtually every single federal case said that it was not an individual right. Heller obviously changed all of that. And today, whether you agree with the Heller decision or disagree with the Heller decision, it's the law, right? So you got to accept it as the law for the purposes of this exam, and for the purposes of the bar exam as well. I don't cover the Second Amendment in detail because they just don't test it on the bar exam. If you go to the National Conference of Bar Examiners website, they have outlines of all the courses, and there's nothing mentioned about the Second Amendment, nor have I seen a Second Amendment officially released question on the bar exam. So you may get it through incorporation. They may ask you a question about, whether the Second Amendment is incorporated, and you have to know that it is, okay? But you're not going to get, I can't guarantee this, but I can assure you with close to certainty that you're not going to get a question on the application of the Second Amendment, okay?
So we don't have to know that for this exam either.
You don't have to know the scope. You don't have to know how the Heller case is decided for my exam.
Thanks.
Okay. You do have to know how the McDonald case was decided because it did incorporate the Second Amendment. Yeah. Timms versus Indiana. This is our newest case. And this is the one that incorporates excessive fines. Excessive fines are unconstitutional. This case was written by Justice Ginsburg, wrote the majority opinion. There were some dissents, a couple of dissents in this case. So Timms apparently was a low-level drug dealer. He is charged with dealing controlled substance, receives a relatively minor sentence, 1 year of home detention, 5 years of probation. He must participate in a court-supervised addiction treatment program, and he got a total of assessment of fines in the amount of $1,203. Prior to his arrest, he had purchased a Land Rover SUV worth about $42,000. The police seized that vehicle, and is very often the case. A lot of states will forfeit any property that is used in the commission of a crime. So it's very common to see the vehicles of drug dealers being seized, and then eventually the federal government will sell them off at an auction. Sometimes even real estate, they'll do that with. I'll tell you a quick story. I own a boat, and I love boating. And my sister and her husband and a set of their friends, a couple, were on the boat with us one day. We keep it in Chatham. We had gone out to the Barrier Beach in Chatham, North Beach. We spent the day just sitting in the sand, listening to music, and playing beach bocce, and just having fun. We got back in the boat, and we were heading back in, and my sister's friend decides to light up a joint on my boat. So this is a 60-something-year-old guy, pulls out a joint and lights it up. And I said, put that out right now. Throw that over the side. you can't do that. He says, we're in Massachusetts. What's the big deal? I said, no, we're not in Massachusetts anymore. We're on the federal waters. And this is federal territory. And if the Coast Guard stops us, and there's a Coast Guard station in Chatham, if the Coast Guard stops us, they're gonna forfeit my boat, okay? They're gonna take it because you decided to light up a joint on my boat. And so he threw I'm sure he had more in his pocket, but he threw it over the side. So that's a lesson for you when it comes to marijuana. Even though it's legal in Massachusetts, it's not legal federally.
That's a cute story.
What's that, Jenny?
I like that. That was a cute story.
Oh, so yeah. If I saw Kelly's Heroes, it was so long ago, I don't remember it, Jenny. So in any event, back to Tim's. So that's my closest rub with the law, I guess. Luckily, there were no Coast Guard in sight. Tim's has his SUV forfeited, and he sues to get it back. Apparently, the Indiana Supreme Court says no, that's a proper forfeiture, and he says this is an excessive fine. You know, it was a relatively small drug charge. The fees that I had to pay were only $1,200. This is in violation of the 8th Amendment's excessive fines clause. So now we need to know whether the excessive fines clause of the 8th Amendment is incorporated. Is it a fundamental right to be free from excessive fines? Is it part of the ordered liberty scheme that these cases are talking about? And Justice Ginsburg goes and, you have the case. So you see, she essentially, looks at the history of the prohibition on excessive fines all the way through the Anglo-American legal tradition, and concludes, and here's her quote: in short, the historical and logical case for concluding that the 14th Amendment incorporates excessive fines is overwhelming. Protection against excessive punitive economic sanctions secured by the clause is, to repeat, both fundamental to our scheme of ordered liberty and deeply rooted in the nation's history and tradition. Okay. So by the way, you know that a lot of states have a racket with the tolls and the transponder fees, and I'm waiting for one of these cases to come up. Apparently, if your transponder doesn't work, they take a picture of your license plate and they send you a bill for the toll. So you might get a bill for like $3 in the mail. And if you don't pay it within 30 days, then all of a sudden it doubles to like $6. And then if you keep not paying it, I guess these people who like missed the $3 toll are told, when it comes time to renew their licenses and stuff, are told that they have to come up with like $1,500 in order to pay off all the penalties and fines that have accumulated by you missing that toll. I could imagine seeing that case come up as an excessive fines case someday as well. All right, let's move on to the state action doctrine. And we'll start with the civil rights cases. The state action doctrine, unfortunately, is about as these cases are about as inconsistent as anywhere else. Okay. So, and again, it depends on the particular judicial philosophy of the judges who are comprising the Supreme Court. So you're getting all kinds of different holdings in these cases. In this area more than any, there's gonna be a state action doctrine question on the bar exam, I can promise you that. Which means there's gonna be a state action doctrine question on my exam, I can promise you that as well, okay? It's really important to read the cases. I've stressed that the entire semester, I'm gonna keep stressing it. because what you're gonna see are fact patterns that you remember. And if you remember whether one of the exceptions to the state action doctrine applied to that fact pattern, you're gonna be okay. Okay? Even though the decisions are inconsistent, you don't go by the rule of law that's decided because they conflict. You go by the fact pattern. Does it work in that particular case? Because you're going to see that the cases are all over the place. So we start with the cause of the whole state action doctrine is the civil rights cases from 1883. Not long after the post-Civil War amendments were ratified, the 13th, 14th, and 15th Amendments, Congress passed public accommodation laws, and they called them, the Civil Rights Act, okay? And they wrote them as if they were public accommodation laws. So what they say is, if you own a place of public accommodation and you refuse entry to a person of color, which would violate the 14th Amendment if it were the state that were running this place of public accommodation. The Civil Rights Act said, you are guilty of violating the law and you're going to have to pay fines and consequences. So this is a consolidation of a bunch of cases. United States versus Stanley, United States versus Ryan, United States versus Nichols, United States versus Singleton, okay? So the people who are swept up, charged with violating these public accommodations laws, the civil rights laws, challenge it, and their argument is the state action doctrine. And the state action doctrine is that the Constitution only protects us from discrimination by the state under the 14th Amendment or discrimination by the federal government. It doesn't protect anyone from discrimination by other private individuals who are not state actors, okay? And that is the general rule of the state action doctrine. The defendant has to be a state or some political subdivision of the state, or the federal government, or some political subdivision of the federal government. If it is not, then the Constitution does not protect. Many states have parts of their Constitution and also statutes that do protect us from discrimination by private individuals. The big statute of Massachusetts is Chapter 151B, and it protects from discrimination by private individuals, okay? So the court here in an 8-1 decision says what we just said. Congress can't pass statutes prohibiting discrimination by private individuals. They can only pass statutes that help them enforce the 14th Amendment against themselves, for suits against them for discrimination by states and discrimination by, not themselves, but discrimination by states, okay? Look at the concluding paragraph here. Individual invasion of individual rights is not the subject matter of the 14th Amendment. It has a deeper and broader scope. It nullifies and makes void all state legislation and state action of every kind, which impairs the privileges and immunities of citizens of the United States, or which injures them in life, liberty, or property without due process of law, or which denies to any of them the equal protection of the laws, okay? So the 14th, 13th Amendment, 14th Amendment, none of them apply to private actors. They only apply to the state, okay? There's your general rule here on slide number 41. The Bill of Rights protects individuals from constitutional violations by governments, but not by private actors, okay? Now what happens is the states got really, really clever. And when the states wanted to discriminate, they would set up a straw man who was a private actor. They would, make him the front man, so to speak. Straw man's not a good analogy. They'd make him the front man. And then when the discriminatory action was challenged and the state gets sued, what does the state say? Not us, it's this private guy. And there's no constitutional no constitutional claim against a private actor. And we'll see in this case, the Adams versus Terry case, the so-called Jaybird Party case in Texas, just how clever the state can get in trying to suppress the vote of African Americans. Okay, so the courts then decided to create exceptions to the state action doctrine to deal with these clever state governments or political subdivisions of the state that are sort of getting around, perpetuating their ability to discriminate by claiming that they're not state actors. There are two exceptions, we'll cover them: public functions exception and the entanglement exception. You're going to have to learn sort of the definition of each to be able to apply them. The public functions exception: does the private entity exercise powers, here's your big language, traditionally and exclusively reserved to the state? Okay, so is it a private person who's exercising powers that are traditionally and exclusively reserved to the state? In other words, it's the state in disguise. Okay. The second one, the one used more often, is the entanglement exception. Here, although it's the actions of a private actor, the state either affirmatively authorizes or facilitates the discriminatory conduct by the private individual. Okay? And then there, the question is going to be just how far the court is going to go in, claiming whether there's a facilitation of the private conduct. So does the mere fact that the discriminator is licensed by the state make the state responsible? Well, we'll see. The Moose Lodge case deals with that we're about to talk about. Okay. So our methodology is simple. First, you apply the general rule. The protection of the Bill of Rights and the 14th Amendment, sometimes the 13th and 15th Amendments, only apply against governments, not against private individuals. And then you look at the two exceptions, and there are your two exceptions: the public functions exception or the entanglement exception. All right. I'm going to sort of summarize quickly the exceptions. We'll begin with the public functions exception. And again, rather than running through all these cases with you, I'm going to sort of just address them off your slide. And I've broken these cases down into categories of, what kind of facts are presented in these cases. So the first one is private utilities operating under a government-created monopoly. So you think of electricity. I happen to live in Andover, and Andover is in the Merrimack Valley, and most people in the Merrimack Valley were serviced by National Grid. National Grid is about to be kicked out of the state of Massachusetts because of the explosions that occurred in the Merrimack Valley. Was that only 2 years ago? Would that have been 2018? I think that's about right. I was including my landlord-tenant class. And as we were walking out, one of the students put on his cell phone and said, "You live in Andover?" And I said, "Yeah." He said, "There are houses exploding around Andover." And there were. Go out for a walk in Andover, you see some of them haven't been repaired yet. National Grid is essentially a monopoly for, electricity in this area. And Columbia Gas is my gas monopoly in this. I'm sorry, it's Columbia Gas, not National Grid. I didn't mean to defame National Grid. I'm going to enter my retraction right now so they don't sue me. It's Columbia Gas that's about to be thrown out of Massachusetts. Yeah, Yeah, so I guess Eversource is going to be the replacement. My mother-in-law, my 89-year-old mother-in-law, so she would have been 87 at the time, was out of her house. It happened like September 14th or something like that. She was out of her house until after Christmas. That's how long it took them to, her house didn't explode, but they had to replace her furnace and, pipes for, it was a mess. It was horrible. So think about utility companies. I would suggest also that Comcast, which I guess is Xfinity now, and Fios, which is Verizon, would fall into the same category. We're lucky enough in Andover to have a choice of the two. And so what do you do to keep when you have a choice of two, what do? Is every 2 years, when your contract runs out, you call them up and say, I'm switching to the other one. And all of a sudden you pay about half the price that you've been paying for the past, year or whatever. Again, that's sort of like a utility. Television is sort of like a utility that's operating under a government-created monopoly as well. Here, the big case is Jackson versus Metropolitan Edison Company. A woman got her electricity turned off for failure to pay her bill. She was not afforded the right to a hearing, and she said under due process of law, she was entitled to a hearing in the case. She probably would have been if it were a liberty or property right to receive your electricity. But Chief Justice Rehnquist wrote the decision and said, no, this is not, the provision of utilities is not traditionally exclusively reserved to the state. Okay. Now, it is true that some towns in Massachusetts, not many, have their own electric utility companies. I grew up in the town of Belmont, and Belmont has the Belmont Electric Company that's owned and run by the town. And the only thing that's cheap in Belmont, I can't afford to live there anymore. The only thing that's cheap in Belmont, it's location, right? The only thing that's cheap in Belmont is the electricity. Everything else is incredibly expensive.
Some of the houses on the Watertown line are not that bad. You should check them out if you're interested. I live in Watertown.
Karen, I've become a country boy. I've lived in
Okay.
Andover since 1985.
It's cheaper.
My wife pulled me away to the country. So, public utilities are not traditionally exclusively reserved to the state. Therefore, they do not fit within the public functions exception. There is no right to a hearing if your electricity is going to be turned off. That doesn't mean that states can't provide their own due process rights or statutes to do it. I believe in Massachusetts, if you request a hearing on, losing your electricity for failure to pay, I believe that you're entitled to it in Massachusetts. Whatever.
Yeah, I think fuel assistance, is behind that, and you are entitled, I think.
Yeah, no, I think it's been for a long time for whatever reason.
Yeah.
Management of private property. You got a couple of cases here. These cases are almost like Twilight Zone cases, right? So Marsh versus Alabama. There's this town in Alabama where if you drive into it, it looks like any other town. It's got a police department, it's got a post office, it has stores, it has public parking, it's got streets that are maintained. The only problem is it's not an incorporated town. It's a company town. It's owned entirely by a private company. And the people who live there are obviously working for this company. And so, we're going to see when we get into individual rights, you're gonna develop a soft place in your heart for Jehovah's Witnesses, because they are the most discriminated against religion in all of these con law cases that we're going to take a look at, particularly the free speech cases that we're going to take a look at. And one of the reasons why they're discriminated against is because they proselytize. they tried to recruit others to come into the religion. And as we know, from if you lived for any amount of time, you have probably had a Jehovah's Witness walk up to your door to ring the doorbell and try to engage you in a conversation about their religion. And if there's obviously a free speech right to do this on the part of Jehovah's Witnesses. So in the Marsh case, this is what happened: is this poor woman comes into town, she starts proselytizing, trying to recruit, and then she gets arrested for breaching the local laws. And she says, well, I have my free speech rights. And what does the town say? No, this is not the government. This is a privately owned town. You have no rights in this town. Okay. This time, however, the court says, well, operating a town is a traditional, exclusive function that is reserved to states. The history of operation of cities and towns is that they're done by the state. They're incorporated by the state, and they're traditionally done by the state. And this looks in every single way like a public municipality. So therefore, we fit within this public functions exception. She does have the right to, free speech. Evans versus Newton. This is the town in Macon, Georgia. Trivia question: who's from Macon, Georgia? What classic rock band? They're not originally from Macon, Georgia, but it's where they lived at the end.
Fleetwood Mac? No.
Nope.
Black Crowes?
Nope. It's the Allman Brothers.
Oh.
Dwayne Allman was killed on his motorcycle in Macon, Georgia, and that's where they were living and recording. In any event, here you have this wealthy white man who donates in downtown Macon a patch of land to be used as a public park in Macon. And he puts one provision on the donation, which is that it can be used only by white people. Over the years, the town maintained this park, took charge of it, and eventually, to its credit, started allowing all people to use the park. And the trustees of the trust eventually sued the town to prevent them from allowing non-Caucasians to use the park, saying that it was part of the original donation to the town. And the claim was, this is private land, therefore, there is no right to claim discrimination as a defense. Well, the Supreme Court said, well, it may be private land, but it's being maintained as a public park. And this is traditionally exclusively reserved to the state. So we're going to fit this one within the public functions exception. There's a bunch of cases in your book on shopping malls. Shopping malls are not traditionally exclusively reserved to the state. So therefore, the shopping malls do not come within the public functions exception. The cases went one way and then another eventually. But the way it is right now, a mall or a shopping plaza is private property. It doesn't fit within the public functions exception. Then there are the election cases, the one that I'm telling you about. In some county in Texas, the Jaybird Party, which was an offshoot of the Democratic Party, and in the South, Democratic Party, most states were a one-party state, and they were Democratic, and most of the segregationists were Democrats back then. It shows you, how the Democratic Party has sort of changed over the years. This county decided to essentially allow this private political party, the Jaybird Party, which was an offshoot of the Democrats in the county, to essentially take over the voting registration system. And so what it did was it basically looked at the public records and determined every single person who was at least back then 21 years old. It used to have to be 21 to vote, not 18, who was at least 21 years old and who was white. And what did it do? It registered them automatically without them even having to come in and to register for the vote. And what did it do with all the persons of color? It didn't register them. And when they came to ask to get registered to vote, they'd say, no, we're not going to do that. And they'd say, well, there's the 15th Amendment. You can't prohibit us from voting. And they says, not applicable to us. We're a private political party. Okay. And this is exactly the type of reason why there are exceptions to the general rule of the state action doctrine. Because, you know, governments and private parties sometimes get very clever and find ways to set up the front man, here the Jaybird party, to do the discrimination work that the government otherwise would be trying to do itself. So the court, you know, looked right through this and says, traditionally, exclusively voting is within the province of the state, not private parties. Here, a private party has captured that function. We're going to fit them within the public functions exception and make this private person liable for constitutional violations. Then there's the private entities managing or regulating schools. Generally, this one does not fit within the private functions exception. Believe it or not, there is not a long tradition of public schools being run by governments in the United States. The United States for, I don't know, its first 250 to 300 years, you know, from the original founding of the America, which was not even the United States yet. Schooling was a private function. It was either done at home or it was done privately. Most children worked in agricultural settings and never really left the farm to go to school. It wasn't until the 19th century, the 1800s, where we started to get public schooling pretty much widespread. I think we can say it's pretty much recognized now as a public function. Yet in these cases, if it's a private school, here in Rendell Baker, you have a school for troubled youth, which is a private school. And basically the public schools send their troubled youth to this private institution and pay the private institution to educate these kids, okay? So their entire source of funding comes from the government. But the court says that that is not enough to make it fall within this public functions exception. Just because you enter into a contract with the government and you earn money from the government, you're not necessarily a government entity, nor should you be treated like one, okay? So in these cases, no, the public functions exception does not apply. Let's look at one case. It's a new case. Kind of shows you the different approaches of the conservative justices versus the liberal justices, so to speak. Manhattan Community Access Corp versus Halleck. This is also, we've done, I think we looked at one other case written by Justice Gorsuch, who was President Trump's first appointment to the Supreme Court. That's the only one I've seen in this course. This is the first case we're going to read that was authored by Justice Kavanaugh, who was Trump's second appointment to the Supreme Court. So you guys know, where is it? I'm trying to think in Andover. I have Fios right now, Verizon TV. And, you know, you go and you hit, I don't know, the 20s or 30s or something like that. And all of a sudden you get all the public access channels. You know, you see the local hearings that are going on, and then a lot of them are just blank and they're not even up or whatever. You know, under these cable laws, the cable companies are required to maintain these public access channels and essentially make them available for private citizens to use. New York City had his, well, not even all of New York City, I guess Manhattan had Warner Cable, and it basically created this private access system and set it up as the official name is Manhattan Community Access Corp. It's a private company. It's not public, and it's known as the MNN, the Manhattan Something Network. I don't even know what the second N stands for. And they're exercising editorial function over private citizens, telling them that they can't come on and speak if they're going to say, particular viewpoints and the like. And so the private citizens sue, and they say this is a violation of our First Amendment rights. And it's a 5-4 decision, and there's a very sharp dissent by Sotomayor. The court says running a public access cable channel is not a traditional exclusive public function. Kavanaugh points to the history of access to channels in Manhattan, says private nonprofit organizations and other public and private community organizations such as churches, schools, libraries use it. They're not engaging in governmental functions. So his conclusion down here at the end, in short, operating public access channels on a cable system is not a traditional exclusive public function within the meaning of this court's cases. Justice Sotomayor dissented, a very clever dissent. The court tells us a very reasonable story about a case that is not before us, is essentially how she starts. And she says, essentially, this is a public forum. The state requires public access. The government is required to provide it. And the government has chosen to put a private entity up to run it and hide behind the shield of the of the private entity that's running it. In a way, they don't say it in this case, but in a way, this case looks a little bit like the Terry v. Adams case, the Jaybird case. Government requires public access to television stations and then sets up a private entity that's allowed to exercise editorial control over free speech. Entanglement exception. So this is our second exception. And I'm going to do the same thing that we just did with the traditional public functions exception. Here's our definition again. If the government affirmatively authorizes, encourages, or facilitates private conduct that violates the Constitution. Now, every single one of these exceptions creates a slippery slope. The key is where does it end? Because you'll see under some of these, you can almost put anything that a private individual does under this exception, okay? So the first situation are judicial and law enforcement actions. Big case is Shelley versus Kramer. Here you have a private land use restriction. And we will do private land use restrictions in real property for most of you next semester. Some of you have already done covenants running with the land in property law, but others have not. Most of you have not. So here in Shelley versus Kramer, there's a private land use restriction, a covenant running with the land that is discriminatory. It says shall not sell the property or lease the property to anyone who is not white. And of course, the owner goes and he does that, and it's claimed that he has violated the private restriction. He says it's discriminatory. They come back and they say, no, it's a private restriction. It's not a zoning law that discriminates on the basis of race. It's a private restriction. The Constitution does not apply. Well, the Supreme Court disagrees. The Supreme Court kind of broadens the approach here, and it doesn't look at the function itself. It looks at a little bit beyond the function itself. And it says, well, let me ask you a question. Where are we sitting hearing this case? In a court. Is a court part of the government? Yeah, of course it is. It's one of the three branches of government, right? And what's the remedy that the person trying to uphold this discriminatory covenant is seeking? An injunction. And who issues the injunction? The court, the government. So this private restriction wouldn't exist without the ability to enforce it by the government, by the court system, essentially. So here they fit this in as an exception to the under the entanglement exception to the state action doctrine. Okay. Now this is really a slippery slope. Virtually everything, every time you could almost say under this that every single contract is an act of the government. Because if I'm going to bring a breach of contract action, I'm going to have to bring that in a court, right? And the government's going to get involved. You see the danger of this type of argument? On the other hand, do you see the danger of not having this type of exception, right? And so I think what the court here is doing is kind of walking a fine line, okay? And it's why these cases are so wildly inconsistent with each other. There's another couple of cases that come along with this. There's two Edmondson cases. I forget which ones they are. They're different Edmondsons, but the name Edmondson is in them. One of them involves the ability to get a pre-judgment attachment on property without a hearing. And it's claimed that this is unconstitutional, it violates the due process clause. And the claim is, well, the person going in and getting the attachment is a private party. The court says, no, what's it using in order to get the attachment? It's using the courts. So it falls right within the Shelley versus Kramer. And then there's another one. The Supreme Court has outlawed, well, not outlawed, but prohibited the use of peremptory challenges in jury trials for discriminatory purposes. So it's long been the law that in a criminal case, if, say, a prosecutor excuses a juror under one of his peremptory challenges, that's a challenge without cause. You get a certain number of them. If the state prosecutor disqualifies someone because of their race, that's unconstitutional. Person will get a new trial, okay? This other Edmonton case ended up extending that to civil trials as well. So if you're disqualifying people in civil cases because of the color of their skin, it's unconstitutional. But the claim here was, well, wait a second, this is a civil case. It involves two private parties. The party who is excusing and discriminating and doing it is a private party, not the government. So the Supreme Court says, yeah, but it's the government that set up the right to peremptory challenges. So it's the government that's created this ability to discriminate by using them. And they're sitting in a freaking court while they're doing it. So, you know, again, this falls within the tent of the Shelley versus Kramer case, traditional law enforcement actions. Second is governmental licensing and regulation. You got two different cases which go in two different ways here. The Burton versus Wilmington Parking Authority. Wilmington, North Carolina had a public parking garage, and within it was a private restaurant. It rented space to the individual who owned the restaurant, and the restaurant refused to serve African Americans. Burton sues, claiming his constitutional rights are violated. What's the defense? The defense is, this is a private restaurant. Yeah, but you keep renewing their lease. It's in a public space. It's associated with the town of Wilmington. And on this one, it says it falls within this entanglement exception. The court does not go that far. Later on in the Moose Lodge case, the Moose Lodge was kind of like the Elks, maybe, you know, that type of a fraternal organization, or the Knights of Columbus, sort of the ones that you know you would recognize around here. This was one, I think it was in Pennsylvania. The Moose Lodge did not allow African Americans to become members. And you know, the old Groucho Marx line, I would not join a club that would have me as a member, so to speak. Who would want to be a moose? And so the claim here is, you know, well, we're a private entity, we're allowed to discriminate. And well, wait a second, you're licensed by the state. You know, you serve alcoholic beverages. You have a food license, you have an alcoholic beverages license. You're highly regulated by the state. And Chief Justice Rehnquist, who writes the decision, says, no, that's not enough. Being highly regulated is not enough. Just like the utility companies are incredibly highly regulated, but that's not enough either. 3 cases come under the government subsidies cases. Norwood versus Harrison. There, the state of Texas was giving out free textbooks to private schools as well as public schools. And some of the private schools discriminated on the basis of race. And so the court found there was a constitutional violation, the violation of the Establishment Clause in doing there, the establishment of religion, in giving out, you know, to these religious schools that would not allow persons of color. The other cases, though, come down just the exact opposite way. Rendell Baker versus Cohn. Again, all of its funding is through the state. Blum versus Uretsky. Everyone who's in this facility has their sort of it's like a nursing home type thing. Has their fees paid through Medicaid, and Medicaid kicks them out, doesn't give them a, I'm not sorry, not Medicaid, the home kicks them out, doesn't give them a hearing. They claim it violates their due process. In both of these cases, the Supreme Court says no governmental action is involved, okay? Voter initiatives permitting discrimination, the Reitman case, you see these referendums once in a while. You know, for example, the law will allow people to enter into discriminatory private covenants and the like. Here you have a state enabling the discrimination. So they say that it is a state actor that's involved.
Can I ask a question? No.
Yeah, go ahead, quickly.
Okay, I was just gonna say, on the exam, do you care if we just explain the law and say alternative and just explain it and not do a conclusion with an opinion? Because a lot of these I'm on the fence of, and if you just know the law and explain it, you're probably okay, right?
No, you need to do your analysis.
You want to?
I just don't want a statement of law
All right,
and then a conclusion. You need to apply, you always have to apply it to the facts.
all right. So you do want us to make
Yep.
it,
Yep.
okay, all right.
Yep. Okay. What you see here is what year these cases were decided. The Warren Court, you know, liked exceptions to the state action doctrine. The Berger and Rehnquist courts did not like exceptions to state action. So the earlier cases tend to create these exceptions, and the later cases tend not to fit them in. What I've done for you at the very end, and this might help quite a bit when you're studying, is I've created this state action doctrines exemptions scorecard. And so first one is the public function exemption. Does it apply? And the cases on the left are yes, it does apply. The cases on the right are no. So you can see Marsh versus Alabama, that's the company town case. The Jaybird Party case. In the public park case, yes, the public functions exception applies. Does it apply for municipal utilities? No. Shopping malls? No. Okay. And then I've done the same thing with the entanglement exception. Does it apply? Yes. Covenants for racial restrictions. These are just all the cases that we've talked about. I don't have to go through them now. And to the right, obviously, is the ones where the entanglement exception does not apply. One case we did not talk about, I'll spend 2 minutes on it, is this, can you guys see my cursor moving at home on the screen?
No. Oh, yeah,
No.
right now, yes, yes, yes.
Yeah, so bottom left, private athletic associations that control virtually all state scholastic sports between public high schools. Massachusetts has the MIAA, which does exactly this. If you play a high school sport, you're likely playing under rules created by the MIAA, which is a private entity. However, it's really taken on a state function here, the Brentwood Academy says. And so if the MIAA discriminates on the basis of gender or race or anything like that, it will fall within this entanglement exception, okay? And it's essentially the exact same case as the Brentwood Academy case, all right? All right, guys, we've used up our time. I used up almost all of it. We didn't get to start economic substantive due process. We will start that on Thursday. And I'll see you then. I will be getting my, answers to the quiz out a little bit later on this afternoon, okay? You guys take care.
Thank you. Have a good day.
Thank you.
Thank you. You bet. No, I think we moved and got a fair amount done.